So it's my great privilege to be able to introduce our keynote speaker today, which is Barbara Findlay, KC. And if you ask Barbara herself how she would like to be introduced, because I've done it, others of you have as well, I'm sure, she will tell you to say, quote, Barbara Findlay is a fat, old, white, queer lawyer with disabilities who was raised working class and Christian on the prairies. All of those aspects of her identity inform the work she does as a lawyer. Well, while that reveals a fair bit about her character, it doesn't shed much light on her accomplishments, which are many and varied. Barbara has been practicing law for over 45 years, focusing primarily on queer, trans, and non-normative families. Her work has reached far beyond the individual clients she has served. And just picking a few things here at random, as most of us know, it was Barbara's advocacy that was a big part of why BC became the first jurisdiction in the world to allow lesbian co-mums to be registered together as a child's parents when their child was born. A big part of why same-sex couples can marry in this country and why there is now a neutral gender option on BC birth certificates. Recently, Barbara has been working tirelessly as an advocate for trans youth. She was awarded the CBA of BC's Georges A. Goyer QC Memorial Award for Distinguished Service in 2020 and CBA National's Louis Saint Laurent Award of Excellence in 2021. One more thing. A few years ago, the Honorable Donna Martinson, KC, wrote a profile of Barbara for The Advocate. In it, she said, quote, for Barbara, access to justice for her clients and her community means that the law must have justice on offer, a justice that is nimble, elastic, changeable, and transformed by new thoughts and values, rather than one that catches up to them years later. I loved that quote, and it seemed a fitting introduction to Barbara and the topic that she will be speaking to us about today, which is all in the family. Thank you, Barbara.
Thank you very much, Linda. And I want to thank Elder Marie Reed also and acknowledge that I too live and work on the lands that my ancestors stole from the Squamish, the Tsleil-Waututh, and the Musqueam peoples. I'm very grateful to Linda and to Catherine and to the folks in the background who contributed energy and joy to the creation of today. And congratulations for pulling it off. It was a lot of work. I want to begin by acknowledging that we are collectively in an extinction event. We actually are not sure at this moment whether the human race will survive. We live our lives in the shadow of that unprocessable truth. But it is a truth that, to me, must inform the ways in which we move forward in all of the areas of our lives and our practice. Because if we ignore the reality, we will certainly fail to cope with it. I'm very fortunate to have someone who's going to move the slides for me. And this is, for an old person such as myself, this is a great help. So could I please have the next slide? I come to the law. I come to the law as a stranger at its gates. When I went to law school, women constituted 4% of the legal profession. And no part of the law school admitted my lesbian self. I found the other lesbian in my law school class on the first day. My gay torts professor came out to me in the first month. But this was all entirely secret. It was so secret that none of us even questioned the secrecy. The law school certainly did not recognize me, did not take cognizance of me, and it most certainly did not recognize my family. I put that word in quotation marks because at the time it was a word we did not even use about ourselves. When my parents came to visit, my roommate and I constructed a second bedroom to manifest a roommate relationship. When there were social functions, I went alone. Sometimes we described our home life using a different pronoun for the other, so that we suddenly had an acceptable heterosexual narrative. There was safety in that invisibility. There was danger in being seen. There was no way to claim that I was family. At the time, we didn't even have for ourselves the word partner. We called each other our lovers, because even to ourselves, the identifying piece was who we had sex with, not who we made family with. Lesbians had children, of course. Most of the children of lesbians at the time were children that they brought with them when they left heterosexual marriages. Having to go to court with those women, with those stories, meant that the children almost always ended up with their fathers. As late as 1993, I had a judgment from a court in Cranbrook saying, of course, my client was free to pursue her adventure of a lesbian lifestyle in Vancouver, but he could see no reason why the children needed to be part of that adventure. In Vancouver, for a while, there was even a group called the Lesbian Mothers Defense Fund, whose job it was to raise money for the inevitable, expensive, and usually useless court proceedings. When I went to law school, it was only 5 years since the Divorce Act had been modernized to permit no-fault divorce. I was thinking the other day about what that meant for women. Before then, we were consigned to a lifetime with the man we married, no matter how we were treated, no matter if we loved each other, and we were economically dependent. I still have the deed of ownership of land that my grandmother owned, but co-signed by her husband, as was then required. For the first several years of my law career, I was a lawyer by day and a lesbian feminist activist by night. I wasn't exactly in the closet. It never occurred to anyone to consider that I might be a lesbian. I didn't have to worry that I was going to be outed. Lesbians didn't like lawyers, and lawyers didn't know that lesbians existed. There was essentially no overlap. But I found myself standing on two icebergs that were slowly drifting apart until finally I could no longer live a life that was structurally bifurcated, where I never spoke queer during the day and I always spoke queer in my lesbian feminist organizing by night. I realized that I was going to have to create a new phenomenon, a lesbian lawyer. And so I went into private practice and advertised myself as a lesbian lawyer practicing for the LGBT communities of British Columbia. That was 1992. And at that time, 25% of the laws of the province explicitly discriminated against same-sex partners and families. 1 law in 4. Paradoxically, queer people were virtually invisible in what we call family law. And family law had already rendered trans people invisible by holding in 1990 that a trans man who'd had top surgery and a hysterectomy and presented through the relationship as a man was not, in fact, a man, because his genitals had not been altered. Not being a man, he couldn't be a spouse and could not make no claim under family legislation. In British Columbia, when I began to practice, the law was that the Vital Statistics Act permitted people to get a new gender marker on their birth certificate if they had surgery and they weren't married, because we couldn't have a result of same-sex marriage. In 1992, we had a queer rights conference here, and we gathered the caucus of lawyers who were there to discuss whether we wanted to pursue recognition under the family law regime, recognizing how patriarchal and sexist it was in its roots and how oppressive it had been to women. We knew that by fighting for inclusion under family law, we would be shoehorning ourselves and our relationships into the het boxes that family law offered, and that we would be excluding anyone whose relationships did not directly mimic, marriage excluded, of course, the monogamous model of straight families. Nevertheless, and with great trepidation, collectively we decided we wanted in. It is monumental to me in retrospect to consider that we had to consider the question of, do we want to be governed by the family law? The answer being yes, the next year, we convened a conference of the queer lawyers doing family law in Ottawa. There was about maybe 15 of us from across the country. We met in Ottawa. The occasion was we were meeting in the wake of a disastrous decision by the Ontario Divisional Court in a claim for same-sex marriage. This is what the illustrious court said. The law does not prohibit marriage by homosexuals, provided that it takes place between persons of the opposite sex. The fact that many homosexuals do not choose to marry because they do not want unions with persons of the opposite sex is the result of their own preferences, not a requirement of the law. We decided collectively that we needed a different strategy. At the time, we were not sure whether the Supreme Court of Canada was going to agree that sexual orientation was a ground that was protected under Section 15 of the Charter. We were even less sure about whether, if the Supreme Court of Canada said that sexual orientation was a protected ground, was that going to protect our relationships? Or was it only going to protect us as individuals confronting discriminatory law? We decided that we would begin by taking cases arguing that same-sex partners were entitled to the same benefits that were available to common law opposite-sex partners. We began by arguing that we had absolutely no intention of touching the sacred institution of marriage. Instead, we were pointing out that our relationships were just like those of heterosexual couples, and we should therefore be entitled to the benefits that accrue to heterosexual common law couples. Pensions, that sort of thing. In fact, It was a pension benefit case, Egan and Nesbitt, that ultimately established our right to charter protection for our relationships. As I began my practice for queers, doing among many other things family law, I acted often for lesbians who were leaving their husbands. My very first question to them was always, "Are you out?" Next slide, please. Because if they were not out, I had to advise them that they should hire a lawyer other than me. If they hired me, their husband's lawyer was certainly going to infer that they were themselves a lesbian, because I was at that time the only public lesbian in family law practice. Many of the women who had come to me could not afford that risk. I acted for lesbians breaking up with their partners when there were children in the relationship, and I acted for the non-biological parent of those children to seek what was at the time called access. I lost every single time, because the law regarded the co-parent of those children, the woman who had with the biological mother decided to have a family. The law regarded her as a legal stranger to the children. But the question of family did not arise only in the context of what we think of as family law. Like straight Canadians, queers wanted to sponsor their non-Canadian partners, for example, but we were unable to do so because of the definition of spouse under the immigration regulations. Rob Hughes, a gay lawyer, was successful in getting permanent residence for Bridget Cole. She had left the nunnery with her Canadian partner, Chris Morrissey, and he had made an application for permanent residence invoking humanitarian and compassionate grounds. That was a start. Rob and Chris and I drove down to Seattle to talk to the head honcho there. Those were the days when immigration applications were decided in offices. In our case, there were 5 of them, 5 offices in the United States. We had a request for him that he permit us thereafter to file queer sponsorship applications as humanitarian and compassionate applications, and that he process them as he would a common law heterosexual relationship. When we met with him and we explained what we were there for, he said, "Of course." That man changed the lives of many, many Canadians. He said to us, but send them to me as independent worker applications with H&C and aid, because that way it won't be as obvious in our statistics. We told all the other lawyers in Canada doing queer immigration work, and until the definition of spouse changed, and that was thanks to Chris Morrissey's work, that's how we did same-sex sponsorships. During the AIDS crisis, we routinely acted for gay men who had AIDS and were dying in hospital. Typically, their parents would come to town to discover that they had a son who was gay, that their son had a partner also gay, and that their son was now dying of AIDS. Commonly and tragically, the common response from the parents was to deny the partner the right to go to the hospital. That caused us to develop a document called a healthcare directive, which the patient could sign, saying who could visit and who could make healthcare decisions. This was long before representation agreements. All it did really was give the hospital something official looking to wave in the face of the homophobic parents. It often worked, at least until the patient died and the parents kicked the partner out of the common home. On one occasion, we had during a funeral service, we had the urn of ashes delivered to our office because there was a fight between the parents and the partner about who would get possession of them. I was able to get for lesbian co-parents the same rights that het parents have in relation to birth certificates. This is the case that Linda alluded to be registered as co-parents of their children. So how we did that was this. We took a human rights case. We pointed out that the practice of the Vital Statistics Agency was to look at the application for registration, decide if the names of the two applicants had one boy name and one girl name, in which case they processed the application, or whether the application apparently had two girl names, in which case they sent it back. In neither case did they look for any genetic connection between the putative parents and the child. And so it was in every area that affects families. I was a lawyer for two lesbians, one of whom was from China. They had never lived together. The Chinese-Canadian partner lived with her sisters. When one of them became ill, the legal and practical challenge was to find a care home that would recognize and respect their relationship of more than 40 years. After 10 or 15 years of litigating common law benefits, when all of our facially discriminatory legislation had been cured federally by litigation and in British Columbia by legislation, and when M versus H in Ontario had extended the family law regime to queers, now it was time. Now it was time for the same-sex marriage case. We coordinated again nationally and developed a strategy. We shared expert affidavits. We discussed the way forward, and we began in 3 provinces. In BC, we met fierce resistance to the case from the queer newspaper, Extra West, on the grounds that if gay marriage was legalized, the queer ghetto would disappear and we would lose community. Now, to win same-sex marriage, we had to overcome Hyde versus Hyde. Hyde versus Hyde is a venerable 1866 decision, and it says, marriage has been well said to be something more than a contract, either religious or civil, to be an institution. It creates mutual rights and obligations, as all contracts do. But beyond that, it confers a status. The position or status of husband and wife is a recognized one throughout Christendom. The laws of all Christian nations throw about that status a variety of legal incidents during the lives of the parties and induce definite rights upon their offspring. What then is the nature of this institution as understood in Christendom? I conceive that marriage, as understood in Christendom, may for this purpose be defined as the voluntary union for life of one man and one woman to the exclusion of all others. The trial court in British Columbia decided that the word marriage in the Constitution was the only word in the Constitution not subject to the living tree doctrine and could never be changed. We won in the Court of Appeal. And Exeter West was right, because the gay ghetto that I knew in the 90s, that we all knew, are now pretty much gone, because now we're normal. Trans people as partners had no further issues after same-sex marriage was legalized, because it no longer mattered what their gender status was. But trans parents have had a trajectory similar to queers. It remains the case that although courts in the shadow of the charter are unlikely to decide explicitly that being trans disentitles one to parental rights, in fact, I continue to advise trans parents to stay out of court at all costs, because I cannot predict that they will not encounter transphobic judges. Why am I telling you these stories? I'm telling you these stories because I want you to look at family from the outside in. Family is a profound and personal connection to people, people who are our kin by birth and people we bond with as an adults. It is an institution that sets the boundaries of who's in and who's out of family. It will come to no surprise in this audience, I think, that family has systematically oppressed women until the last generation or so. But as a refresher, let's see what folks say about the history of family law. We'll have a little poll. I like polls. Could I have the first poll, please? Till what year did men have automatic custody and guardianship of their children after divorce in England? Now, I forgot to check how you're supposed to register your responses, so maybe somebody from CLE can tell people what to do. Or maybe you already know. Pick one of those options and submit it on your poll. Okay, if everybody's had an opportunity, let's see what the results are. And then I'll tell you what the right answer is. It appears that everybody picked 1919. You're more pessimistic than I am. The correct answer is 1839. Let's look at the next poll. The last provinces to permit divorce in Canada were Quebec and Newfoundland. In what year did those provinces permit divorce at all? Okay, let's see what the answers, what people gave us answers there. Okay, we have a variation here. The correct answer is D, 1968. Excellent distribution of correct answers. 60% of the people knew that. Next poll, please. Until what year in Canada was marital rape legal? 1919, 1949, 1968, 1983. The correct answer, I'm sorry to say, is 1983. Prior to 1983, that is to say, long after I graduated from law school, it was impossible to charge the man you were married to with rape. He owned the rights to your body. Slide 7, please. When was the first law enacted that provided spousal support for common law couples in Canada? 1942, 1968, 1972, or 1980? And the correct answer is 1972. And British Columbia was the first jurisdiction in the country to permit common law partners to claim spousal support. Finally, in what year, next slide, please. In what year did the Supreme Court of Canada recognize that spousal support laws should take into account domestic contributions? 1968, 1972, 1983, or 1992? The correct answer is 1992. So that gives you an idea. Thank you for those slides. That gives you the idea of the law that my forebears, my British forebears, brought to Canada and imposed when they got here. If I could have the next slide, please. Because European colonizers were unable to see Indigenous family forms at all. The process of colonization in British Columbia was to run roughshod over the very existence of Indigenous nations. Indigenous family forms were by no means the same across the many Indigenous nations in the country that we now call Canada. In BC, many were matrilineal or matriarchal. Some were not. Many Indigenous nations in BC are organized into clans, which are important to the governance structure as well as the structure of relationships, giving permission to the clan members about who they can and cannot marry, but also being integrated into the potlatch system of governance, which combines spirituality, legality, as we understand it, family life, into ways that are not cognizable to the systems of dividing up the world the way we colonizers do. Children were not seen exclusively as the responsibility of the parents who birthed them, but instead had many aunties who participated in their care. Settlers, my ancestors, were completely convinced that their Judeo-Christian customs were superior in every way, and we committed literal and cultural genocide. We enacted the Indian Act in 1867 and defined Indian as any male person of Indian blood and legislated status to be passed through the male bloodline. Women had status rights only as the unmarried daughter or the spouse of an Indian. If they married a non-Indian, they lost their status. Their brothers did not. The discrimination against Indigenous women embedded in the Indian Act was not entirely eradicated until August 2019. In 1986, the Supreme Court of Canada decided that provincial family law, that is to say, a provincial law of general application, did not apply on reserves. The result was that none of the matrimonial property provisions applied on reserve. The BC Native Women's Society brought an application in 1996 against the federal government for a declaration that the feds were in breach of their fiduciary duty to Indigenous people because they were treating the beneficiaries of their fiduciary duty, that is to say, in quotations, Indians, unequally by treating women less advantageously than men. But it was not until 2004 that the Federal Family Homes on Reserves and Matrimonial Interests or Rights Act was passed, providing for the local establishment of matrimonial property regimes. The legislated travesties visited upon Indigenous peoples are far too numerous to be recounted in detail here. None of us needs to be reminded of the vicious colonial policies. RCMP were authorized to and did take Indigenous people from the arms of their parents and consign them to residential schools where they died from malnourishment, from sickness like TB, from active abuse. They had no opportunity to learn what a parent was. And then in the 60s, we said, Indigenous people are not good parents. We settlers initiated the 60s scoop, equally racist policies which took children away from their Indigenous families once again, and most often gave them or even sold them to non-Indigenous families. Report after report after report has outlined the racism against Indigenous people in the child welfare system. The Canadian census in 2016 noted that 7.7% of the children under 14 in Canada are Indigenous. But of the children in care in the same age, 52.2% of the children in care are Indigenous. And the courts have continued to follow the best interests of the child test. What could possibly be wrong with that? In considering how race plays as a factor, the Supreme Court of Canada decided that the race of a child or the child's parents was a factor in determining the best interests of the child, and not the context in which the best interests of the child should be determined. That resulted in decisions where the court held that a child was more psychologically bonded to their foster parents than to their own Indigenous parents, and that the non-Indigenous parents had the right to adopt the child. That case, that 2001 case, has been held to be in good law in BC by our Court of Appeal as recently as 2017. Cindy Blackstock's case against the federal government and its criminal underfunding of systems on welfare, child welfare systems on reserve relative to funding for the same services off reserve continues, as recently as this week, to be viciously defended and manipulated by the federal government. Surely what we must do as a first step is to recognize that the rote application of laws about family that apply to everyone in the same way create disastrous consequences, and to adopt a critical lens, especially into standards that appear anodyne. The best interest of the child is an outstanding example. Now, when I started my research for this paper, I looked into Canadian family forms, and up came entitlement applications. Can I please have the next slide? And that immediately raised the question of people with disabilities. Because if you live with a disability and you receive a disability pension, you're not entitled to choose your partner freely. Your partner's income, whether they are a person with a disability or whether they are a person earning an income, will affect the amount of money that you receive as a person with a disability. So in effect, well, the same is true for people receiving regular social assistance benefits. You will be deemed to have a spouse whose income is considered along with your own if for a period of 12 months, not 24 like the Family Law Act, you have lived together in a relationship which demonstrates financial dependence or interdependence, and the relationship demonstrates a social and familial interdependence consistent with a marriage-like relationship. The result is that unlike most families in which both adults are working and therefore have two incomes, people with disabilities are penalized. They are treated as charges to be cared for by their parents. People, therefore, with disabilities often have to choose between relative, and the word is important, relative financial independence and living with their partner. I know people who have rented apartments down the hall in order to escape the impact of that law. So notice that in this area of family law, the state is actually discouraging conjugality by making penal consequences for that. Can I have the next slide, please? When we look at immigration law, we see most clearly what it is that Canada says it means when it says family, because Canada has no difficulty legislating what counts as family for its own economic interest. The clearest example is the live-in caregiver class. Under the live-in caregiver class, you can come to Canada and earn the right to become a permanent resident by working in someone's house to offer childcare. However, you have no right to bring your own family, your own children. So Canada has no trouble separating families when in its own self-interest, it thinks that's beneficial. There is a staggering number of legislative provisions that benefit or penalize family forms. Everything from the Workers' Compensation Act to the Farmers' Food Donation Tax Credit Regulation to the Wills Variation Act to the Income Tax Act. The point is that we embed family as we understand and privileged family in our entire legal system. Next slide, please. I want to argue that the approach that Zara Zuliman and Catherine Wong and Monique Chebier took in determining that a child could have 3 parents, even though the child was conceived by sexual intercourse, is the approach that we should be taking generally to a determination of who is family. In that case, they argued that notwithstanding that the Family Law Act Part 3 appeared to say, if you conceived a child with sexual intercourse, that child could have 2 and only 2 parents. Nevertheless, they were successful in convincing the court that there was a gap in the legislation and that in a triad situation where there were 3 parents, each of whom intended to parent the child, all 3 could be named on the birth certificate. I'm not telling you that case just to shout out my friends, the litigators, but to demonstrate the importance of intention and to suggest, and here I circle back to where I began, to the so-called nuclear family. That family was a rules-based system which privileged men and the primogeniture of the eldest son. It treated women and children essentially as property and privileged and burdened that nuclear family throughout the legal system. I want to propose that we radically reconsider the way we talk about family, particularly in the ways family is embedded throughout the legal system. And I propose that in doing that, we carry forward as the fundamental principle, what is the intention of the parties? We have, at this moment in our collective history, literally an existential crisis. Either as a society, we are going to survive or we are not. It is, I think, self-evident that our best chance of survival is to create, support, and maintain relationships of mutual interdependence, emotional interdependence, financial interdependence, functional interdependence among us, so that we do not have elders living alone, we don't have people who don't have connections. This is not, believe it or not, this is not a radical idea. This is an idea that was explored in depth in 2001 by the Law Reform Commission of Canada, who said, hey, wait a minute, we're going to take a look at at all of the federal laws that create consequences for same-sex, beg your pardon, for relationships. All of the places where legislative consequences are tacked on to family forms. And they proposed that they examine all of those relationships in a systematic way, looking at first, what are the objectives and of the legislation or the policy, and are those objectives still legitimate? Secondly, are the relationships that are embedded in those laws relevant to the objective of the law? Third, Assuming that those relationships are relevant, could the law allow individuals to decide for themselves which of their close personal relationships should be subject to the law? Now, notice what we just did was ditch the idea that what you need to be embedded in law as family is some version of either a conjugal relationship or a parent-child connection. And in its place, I propose that we consider the intention of the parties. That might look like a registration regime. And in fact, in the wake of the same-sex marriage cases, some of the provinces legislated what they called registered domestic partnership, or we called it derisively marriage light. But it offers the conceptual opportunity to make relationships which are not conventionally conjugal, to make those relationships nevertheless have visibility and place in the extensive web of legislated consequences for relationships that now exist. You may think I'm a dreamer, but I'm not the only one. If I could have slide 16, please. Cuba got there before we did. Cuba has just enacted, I think I might want the next slide, maybe. Well, I don't know. We'll see. Cuba's just enacted a comprehensive family code based on principles of intentionality. You can read it if you know Spanish or if you're good at Google Translate. But as you go through the rest of the day, where intention is a given, where the intention is the bedrock of the creation of children through assisted family reproduction, I would invite you to carry with you these lessons. First of all, always look from the outside in. That will be the next slide. We will do no better now than the law did in the 90s with queers at knowing who we leave out. By definition, the relationships I'm talking about are relationships which are currently invisible from the inside place. So we don't know what we don't know. We must always work against that erasure. There will be strategic choices, some of them the same as the ones we queers had to make. Do we, next slide please, do we try to put ourselves, shoehorn in the new categories of people into the existing legal structures? It won't work, because the relationships I'm talking about are not conjugal. So they're not going to fit. Queer relationships fit, these ones won't. Do we instead demand change to the law to accommodate outsider families? Here I'm looking, for example, at polyfamilies, but that's only the beginning. Or do we must take the status of marginalized people into account, and that actually means, as an intellectual exercise, starting from where the lives of marginalized people are and working from there. You cannot work from the inside out and accomplish justice. You can only work from the outside in. Thank you for the opportunity to speak with you today, and may you intentionally move through the rest of the work. Thank you again.
Wow, thank you, Barbara Findlay, KC. Thank you for your thoughtful and extremely thought-provoking message. I found it a truly inspiring way to open our day today. Your words and work always raise the bar for me, and I'm sure that it's the same for many others in this room as we move forward with our practice, particularly in this evolving area of family and fertility law.